Hello, guys. Sorry about that. So, welcome to another rendition of BZ Watchdog. So, today, I don't know how many of you guys are in here. I was trying to get this set up and wait for some of you guys to come in here for a minute. I don't know how many of you guys are in here. I'm trying to check right now. There we go. 5 watching. Okay, good. There's 5 of you guys in here. Okay, so we're gonna do this. Give me a what's up, guys? Give me a 5x5 if you can hear me. I think you can. Not the bot. Can y'all hear me fine? Can y'all hear me? 5x5. 5x5. So I'll make sure you guys can hear me. Okay, good. All right. I want to go over something real quick. Today is December 7th. And this happened. And I got to share my screen real quick. For anybody who's patriotic, I'm going to do this for my World War II vets. I've got right here.
And at the solicitation of Japan, was still in conversation with its government and its emperor, looking to.
So just want to give you a little word, little speech there, the day that went down in infamy. So going into this, I'll play a little bit by a little bit, but there is about the Second Amendment today. And the reason we're going to get into that is because we're going to talk about some security products. We're going to talk about some stun guns today. You see these right here. We got all these stun guns up called the Lady's Choice. We'll be going into these in just a second. But the reason this is important is because of this video and a couple case laws I'm going to go into here in a second. So with that being said, make sure it's up. There we go.
Kovic, if I could just start with you. Let me ask you a question about the First Amendment, if I could. Does the First Amendment apply to the medium of the internet, in your view?
My understanding is that it does, Senator.
Why would that be true, considering that the internet didn't exist in 1791?
Well, Senator, the Supreme Court has adopted a number of different tests for assessing the constitutionality of different provisions. The First Amendment protects speech, of course, and people speak on the internet. But I would adhere to the relevant test if any First Amendment case were to come before me.
Well, I ask you because the Supreme Court has said something much the same in the Second Amendment context. And in the Second Amendment context, you argued to the Supreme Court that because a particular firearm did not exist at the time of that amendment's ratification, that it wasn't covered. The Supreme Court, covered by the right, that is, the Supreme Court rejected your opinion unanimously in a per curiam opinion. That's the Caetano case. I've got it right here. You've been asked about it. What's interesting to me about this case is there's a lot of division on the United States Supreme Court about a lot of topics, including the Second Amendment, but they were unanimous in this case. It's a very short order, 2 pages, not even really, page and a half, in which they rejected your argument completely out of hand. And I just want to ask you, why did you make an argument that the Supreme Court said held no water at all, so much so that they felt the need to address it in a per curiam decision and to remand the case, saying that the arguments that you made were not to be countenance at all? You didn't get a single vote. So tell me, help me understand, why did you make arguments that the Supreme Court said had previously been made and previously rejected by the same court?
Thank you, Senator. I just would like to clarify at the outset that I did not handle the Caetano case when it was before the Supreme Judicial Court. The case was handled by the district attorney rather than the Attorney General's office at that stage.
So I want to point out what she did was basically she brought a frivolous case to the Supreme Court and tried to go against the Second Amendment. So just to let you guys know, if we go over here to this tab, this is the case they're referring to, okay? It's called Caetano versus Massachusetts. And they're going to talk about it a little bit, but this was a case in this is 2016 was a case in which the Supreme Court of the United States unanimously vacated a Massachusetts conviction of a woman who carried a stun gun for self-defense. And that's why we're kind of getting into this today, because I've got these self-defense products that are great for anybody. Now, I do have a black one that's called the Blackjack. I just kind of want to go into just a quick video of this real quick. Show you this. Just to show you that real quick. So now that's the lady's choice, and this is why I'm bringing up Caetano, because this was vacated, and it says that Jamie Caetano was reported to have been hospitalized and in fear for her life after an altercation with her abusive boyfriend. After obtaining several restraining orders that proved futile, Caetano accepted a stun gun from a friend for self-defense one night when her ex-boyfriend confronted her outside her work and threatened her. She displayed the stun gun and successfully avoided an altercation. In other words, she, by mere in fear, scared him away, so she didn't have to do any harm upon that person. However, when police discovered that she was in possession of the stun gun, she was arrested, tried, and convicted under a Massachusetts law that outlawed the possession of stun guns. The Massachusetts Supreme Judicial Court had said her stun gun was not the type of weapon that is eligible for Second Amendment protection because it was, quote unquote, not in common use at the time of the Second Amendment's enactment. Caetano then appealed the Massachusetts court, ruling to the Supreme Court of the United States. That's where the Supreme Court ruled in her favor. Now, just so you guys know, that's kind of what the context of this was. So I'm going to go, yeah, exactly. 2A means bear arms. It doesn't mean firearms. It doesn't mean just guns. It means any kind of arms that are self-defense. Pretending it could be pistols, stun guns, tasers, pepper spray, knives, batons, your hands. I mean, those are all right to bear arms. And people forget that. Now, they're trying to debate whether or not, the First Amendment, because we didn't have the internet back in 1791 when it was ratified, that, she says, well, yeah, that's the First Amendment, Well, what about the Second Amendment, modern times? Well, so basically they're trying to say that she brought a frivolous suit and incarcerated a woman that shouldn't have been incarcerated for trying to defend herself. So with no further ado, let's get back into this video.
The Supreme Court, the argument that I made.
Wait a minute, you didn't, the Caetano case at the U.S. Supreme Court, you didn't handle it?
I did co-author the brief in opposition to certiorari at the Supreme Court,
okay,
but not the Supreme Judicial Court.
I'm asking about the Supreme Court,
sure,
the Supreme Court judgment that rejected your arguments. So you've just confirmed, I think, that you made those arguments to the United States Supreme Court. Is that correct?
Respectfully, Senator, the argument in that brief was slightly different. The argument was that a stun gun is, we argued on behalf of the Commonwealth, not an analog to a founding era weapon. Which the Supreme Court rejected unanimously. The Supreme Court held that the Supreme Judicial Court had misstated the Heller decision in 3 respects. But again, I didn't handle the case in front of the Supreme Judicial Court. So your argument is that your position wasn't rejected unanimously by the U.S. Supreme Court? I certainly acknowledge, Senator, that the Supreme Court summarily reversed the Supreme Judicial Court's decision. I and I would adhere to the Supreme Court's holding in Caetano and reaffirmance of Heller's statements.
Here's what I'm trying to understand. The Supreme Court was very dismissive of your arguments. One of the reasons it was dismissive is it said they've considered these arguments before and rejected them. This is why they then rejected your arguments per curiam, unanimously. So I'm trying to understand why someone who has ethical obligations to the court, why you would make arguments that the court has previously rejected, knowing that they'd previously rejected them. And then here's the other thing that interests me. In this case, the person who had been arrested under this law that the Supreme Court then reversed on was the victim of domestic abuse. And I just want to read a few of the facts here. This is from Justice Thomas and Justice Alito's concurrence in that per curiam judgment. Here's what they say. After a bad altercation, that's from the trial record, with an abusive boyfriend that put her in the hospital, Jamie Caetano found herself homeless and in fear of her life. So she obtained multiple restraining orders against her abuser, but they proved futile. So when a friend offered her a stun gun for self-defense against her former boyfriend, she accepted the weapon. And it's a good thing she did. Because one night, after leaving work, Caetano found her ex-boyfriend waiting for her outside. He started screaming that she was, this is from the trial record, not gonna effing work at this place anymore because she should be home with the kids they had together. Caetano's abuser towered over her by nearly a foot and outweighed her by close to 100 pounds. She stood her ground, displayed the stun gun, and announced, I'm not going to take this anymore. I don't want to have to use the stun gun on you, but if you don't leave me alone, I'm going to have to. And the game that worked, the ex-boyfriend got scared, and he left her alone. You think she shouldn't have had the right to self-defense?
Senator, thank you.
Okay, so everybody in the chat, do me a favor. Put a 1 if you think you have the right to defend yourself, regardless of what the state's laws state. Put a 2 in the chat if you don't think that you have the right to defend yourself if the law imposes laws that say you cannot carry a stun gun or other type of Second Amendment rights. No, those bots are not deleting your chats. What's the matter, you? I'm seeing them in here. So, but put a 1 in there if you agree with the senator with how you should have the right to defend yourself. Put a 2 in there if you don't think you do. I don't care. I don't care about the law. I'm gonna put a 1 in my. I'm gonna put a 1 for myself because I don't care if it's unlawful or not. I'm gonna protect myself. So, but anyways, I'm gonna get back to this real quick. See what this dumb idiot of a lawyer is gonna say here in a second. Judge.
Again, the district attorney made the decision to bring charges in the Caetano case. The Attorney General's office and myself were not involved in that decision, but I certainly recognize
That you argued for it to be upheld before the United States Supreme Court.
Sir, the argument in that brief was that the Supreme Court should deny review of the case.
Right.
But
Which deny the right of self-defense to this person. I'm asking you why.
Senator, my duty as Assistant Attorney General was to represent the Commonwealth in that case when it came to the Supreme Court, and I did so consistent with my ethical obligations.
Your duty is not to make frivolous arguments to the Supreme Court of the United States. And frankly, I question your judgment in what you did in this case, and I question your judgment in choosing to try and perpetuate what is manifestly an injustice to this victim of domestic abuse. I yield the rest of my time.
I'm going to start with Ms. Kobeck. I want to ask you about your work on cases involving Second Amendment, specifically about the Caetano case. The Supreme Court held in Heller, as you know, that the Second Amendment protects the right to own arms that were, quote, not in existence at the time of the founding. It rejected a claim to the contrary as boarding, quote unquote, boarding on the frivolous. But in a few years later, Caetano, you argued that stun guns were too modern so that they were protected. So I'd like to have you explain your thought in regard to that, whether it was consistent with Heller, and at the same time, could you explain why the briefing didn't address the Supreme Court statement that the Second Amendment protected arms that, quote, not in existence at the time of the founding.
Now, I want to stop right there, guys, because look, they got the District of Columbia versus Heller. Let me get this bigger here for you guys on the screen. Let's see, make sure I've got this down here. Sorry, I guess I had my face up there the whole time instead of the video playing. My bad. All right, guys. So anyways, I don't know if this, let me blow that up a little bit more. Okay. Let's see if you guys can see that now. There we go. That's much better. So this one, I'm gonna read this. I'm gonna read this real quick because it's the Dick Heller thing. It's not very long for what I need to read, but District of Columbia versus Heller, 2008, is a landmark decision of the Supreme Court of the United States. It ruled that the Second Amendment to the U.S. Constitution protects an individual's right to keep and bear arms, unconnected with service in a militia, for traditionally lawful purposes such as self-defense within the home, and that the District of Columbia's handgun ban and requirement that lawfully owned rifles and shotguns must be kept unloaded and disassembled or bound by a trigger lock violated this guarantee. It also stated that the right to bear arms is not unlimited and that certain restrictions on guns and gun ownership were permissible. It was the Supreme Court case to decide whether the Second Amendment protects an individual right to keep and bear arms for self-defense or whether the right was only intended for state militias. Now, if you go down here, I'm trying to find it real quick. I saw it earlier. Purposes, where did I see it at? Lawsuit against whoever never owned a gun. It's constitutional scholar. Where did I see that at? I saw it here earlier. Okay, so say that permission on private use of arms activities such as hunting, operation. Okay, where was it? I saw it here somewhere. Grandmother's one of the Second Amendment rights to trust private homes represent the first time because of the kind of the matter that must be found. Sorry, I blew this up so big that I'm trying to find this section here where I saw it earlier. Supreme Court is ruled, extended, law firm, like most Second Amendment right. Wait, is it right there? Okay, that's not it. Here we go. Okay. So in District of Columbia versus Heller 2008, the Supreme Court undertook its first ever in-depth examination of the Second Amendment's meaning. So after a lengthy historical discussion, the court ultimately concluded that the Second Amendment guarantees the individual right to possess and carry weapons in case of confrontation, that the central to this right is the inherent right of self-defense, that the home is where the need for defense of self, family, and property is most acute, and that above all other interests, the Second Amendment elevates the right of law-abiding, responsible citizens to use arms in defense of hearth and home. Based on this understanding, the court held that the District of Columbia law banning handgun possession in the home violated the Second Amendment. Okay, so it basically is saying that you have the right to bear arms. It doesn't matter if it's a knife, it's a stun gun, it's whatever. It doesn't necessarily have to be a handgun. So in other words, what's going on? Invalid request. So in other words, guys, you don't have to have a gun to bear arms. Second Amendment, that could be a knife, that could be a stun gun, that could be a baton, that could be your hands, that could be brass knuckles. That's all Second Amendment stuff. That is the right to bear arms for protection, for defense, to protect yourself and your home and your property. So without further ado, I kind of want to get back into this real quick. I want to show this video again, blow this up so you guys can see it a little better. There you go. That should be better right there. I turned the volume down because I think I get copyright on the music here. So, but if you guys look at this video, I've got like about 9 different colors on this. Comes with a built-in alarm. I don't know if you listen to that thing zap. Got a built-in alarm and everything. So got these on sale from $30.95, currently on special at $19.95 plus tax and shipping. Get them now, lifetime warranty. Get them at Tap Security Products. But we're going to get back into this video to hear what she's got to say to this young man.
Thank you for the Ranking Member Grassley. In my capacity as Assistant Attorney General, I was assigned to write or co-author the brief in opposition to certiorari in the Caetano case. The initial decision to bring charges was made by the district attorney, and the district attorney handled the case at the trial court level and on appeal in the Supreme Judicial Court. So our role, the Attorney General's office took over representation of the case when the case reached the Supreme Court. And our argument in the brief was simply that the Supreme Court should deny the petition for a writ of certiorari. I certainly understand the Supreme Court summarily reversed the SJC's decision in that case, stating that the SJC's decision was inconsistent with Heller in 3 respects. And I want to affirm, Senator, that in every case I've handled involving the Second Amendment, my arguments have been based on Heller and McDonald, and I would adhere to all of the Supreme Court's precedent on the Second Amendment, including its recent decision in Bruin, if I were so fortunate as to be confirmed.
Okay, thank you.
Let's see, Ms. Kobik. Let me come to you. I heard your response on the Caetano versus Massachusetts case and your assertion that you would follow Supreme Court precedent when it comes to Second Amendment rights. So tell me what your understanding is of whether the Second Amendment applies only to militias.
Senator, the Supreme Court held in the Heller decision that the Second Amendment protects an individual right to keep and bear arms.
So you would stick with that?
Absolutely, Senator.
Okay. And let me ask you this. Why is it constitutionally permissible for the right to keep and bear arms, which the Supreme Court has called a fundamental right, that right to bear arms? But that right is subject to the discretionary issuance of a license by a local official.
Thank you for the question, Senator. I know different jurisdictions have different statutes related to licensing. If a case were to come before me involving a Second Amendment challenge to a licensing statute, I would certainly apply the Supreme Court's precedent, including the methodology clarified by the court in the Bruin decision.
Okay, thank you.
This isn't a question. Judge Gray, I may vote for you anyway, but I'll commit right now in front of God and country to vote for you if you'll move back to Louisiana. Judge Flynn, I've read a number of your writings. You wrote an article in December of 1990 entitled Person of Faith, Race and Religion as Experiential Knowledge. You wrote it in a journal called Perspective. And this is what you said, I quote, your words, not mine. The problem with the Christian coalition is not that they are Bible thumpers, parentheses, there are personal beliefs that often result from religious experiences, close parentheses, but that they are bigots, end of quote. Did I quote that correctly?
I believe you did.
Did you write that?
I did write that when I was 18 years old. Or 20 years old, excuse me. I do want to be clear. I do not agree with that today. I wrote that before I went to law school, before I had any kind of
You were a grown woman when you wrote this.
I'm sorry.
You were a grown woman when you wrote this.
I was 20 years old when I wrote it. It was before I had a professional career.
You were in your third year at Harvard?
I was
I've seen you at Harvard,
I was a junior at Harvard.
junior. So you were 3/4 of the way through your Harvard education and you wrote that.
That is correct, Senator. It is
Wow.
20 years before I became a judge. I do
Wow.
not agree with it today. I do want to be clear about that.
Okay. Judge Simmons, let me just ask you a couple of questions. You finished law school in 2004?
Yes, sir.
All right. Have you ever tried a case in federal court?
I have not seen there.
Have you ever filed a brief in federal court?
I have not practiced in federal court. My entire practice has been in the state court.
Okay. Have you ever argued a motion in federal court?
I have my entire practice of over 12 years as a prosecutor has been in state court, Senator.
Okay. Have you ever, you serve as a state court judge. Have you ever presided over a jury trial as a state court judge?
In the 5 years that I've been on the Superior Court bench, I have been in a moving department, and now I'm the supervising judge.
Have you ever tried a,
As a attorney, I have tried.
no, as a judge?
As a judge, I have presided over court trials, not jury trials, sir.
No. So then any opinions, issued any opinions
Court judge, we don't issue written. I've been on the Superior Court.
of review? And what's the standard of review for questions of law? What's the holding in Map v. Ohio?
Map v. Ohio, since I've been practicing as a district attorney for the last 12 years, as well as a Superior Court judge over the last 5 years. I know what the holding is. It escapes me as I currently sit here. But
Okay.
as a
What's the Chevron doctrine? You'll see that a lot.
Yes, Chevron deference refers to an administrative agency that's interpreting its own rule. It created a two-part step test. The first step in that test is whether Congress
Okay.
was clear.
You know it. I got you. What's the political question doctrine?
I have not, as a Superior Court judge and over the last 5 years, and as a deputy district attorney for 12 years, I have not practiced in a federal court. So if I am so fortunate enough to be confirmed, I will obviously apply the applicable law.
Okay, I want to talk about the United States Constitution. Is it a doctrine of plenary powers or enumerated powers?
Enumerated power, sir.
Okay. I yield back 1 second.
So you guys can see that, hell, they a lot of these guys, hey, what's up, GS? You guys can tell that they don't even know what the hell the Constitution means and how to read laws. And these are people that are judges. So, he got huge, or money, wow, down. But just so you guys know, so that's what Caetano versus Massachusetts was overturned for vacated for a woman who was carrying a stun gun for self-defense. And that's why today we are promoting, that's a little big right there. Hang on a second. Yeah, that's what she said. It's a little big. Ah, love it. Sorry, guys. It's raining outside here. Let me back up right there. Let me back that up right quick, right there. Share that screen. I actually closed that one out by accident. So here we were talking about Caetano versus Massachusetts, and then of course DC versus Heller. Those are the two cases that have the right to bear arms. Doesn't matter if it's a pistola, doesn't matter if it's a knife, or in my case, fancy little stun gun like these bad boys here. These little bad chickens here. I got another one, different color right here. If you like, I clicked on it. This is what they call the lady's choice because it has all this built-in stuff. So got these bad boys on sale right now from $30.95 down to $19,995 right there, plus tax and shipping. So get your stun guns today, tapsecurityproducts.com. Without further ado, I want to play a little bit more of this Franklin D. Roosevelt speech, Pearl Harbor. So go back to Caetano versus Massachusetts, guys. So that's the court right there that won on an appeal. You guys should look this up. I'm gonna put this in the sidebar. Let's see, Caetano versus Massachusetts. Here, I'm gonna put this right here in the sidebar for you guys. You should look up that case law right there. That was overturned for carrying a stun gun in the state of Massachusetts, where Massachusetts, Dick Heller did fight for our rights. Chile knows him personally, so does Michael Eline. So, you guys, this is why you're able to carry weapons and stuff like that. You don't need no special permits or self-defense. But you guys got any questions in the sidebar? Take any donations? I'm gonna end this live stream because I got another live stream at 3:30 with Brick and OTVO to cover their video from earlier. But we need to get some donations. I need your help, man. Donations or purchase some products. I need your help. The trolls have put me out of commission, guys. So look here, right here. Look, see the banner. Trolls have put me out of commission. You got your goodies? All right, fantastic, Stomper. Hey, Stomper, why don't you do me a favor and email me or put up like a little video so I can show the video of you opening all your stuff up. What's the matter? You're always broke, but that's all right. Just reach out to me, man. I'll make sure that I get you that special. I might just leave the special up next month after Christmas. I know a lot of people take their gifts back and get different things, so. But lifetime warranty on them. I was just trying to do like 45 minutes this morning, an hour, kind of go over this case law a little bit. I just thought that was intriguing. Because of Dick Heller, this woman got her conviction overturned. So definitely right on. Definitely right on. So let me go back to blowing this up. Boom. Hang on a second. Let me get rid of that screen. There we go. So you guys have any questions? Any questions? Took your rights away from Sandy Hook. I'll take some donations too there, Wasamata. Bum. Cash App, PayPal, Venmo, GoFundMe. I'm surprised the most. The SCOTUS. Not SCOTUS won't, because they're mostly Republicans. They won't do that. They'll always rule in our favor on the guns. Democrats don't want to take our guns away. All right, guys. Well, with further ado, look, about 30 minutes. 30 minutes, okay? I'll be starting that other live. So I gotta get in that other studio. So I will catch you guys on the next live stream. Make sure you guys hit that like and subscribe button. Double tap the screen since we're in vertical mode. And I'll see you on the next one. Later, Gators.